We'll talk about conflicts of interest, ethics, disclosure requirements, but a couple of movie quotes first. I grew up in an era when if a Sunday school teacher could not make a lesson out of the last night's Star Trek episode, they weren't a very good Sunday school teacher, okay? So here's a couple of movie quotes that you could maybe turn into a Sunday school lesson. I'm not bad, I'm just drawn that way. Roger, who said that? Okay. With great power comes great responsibility. Spider-Man, who said that? All the way back there. Sorry. I'm a little fuzzy on this whole good-bad thing. Nobody? Oh, that's my favorite movie quote. I'm a little fuzzy on this whole good-bad thing. Who are you going to call? Ghostbusters. Okay, here's a good one. You must choose, but choose wisely. India? Which one? Last Crusade, okay. All right, conflicts of interest, disclosure, ethics. One other thing I was going to mention, all of these topics we've talked about today have got chapters in this book. I hope you'll examine them. John Bronson wrote the chapter on public debt and financing. Carl Hendrickson wrote the one on the tax system. So by all means, take a look in there. They're not exhaustive answers, but at least it'll get you in the right direction. It'll help you to sound intelligent when you ask the attorney specifically or a specific question. Okay, we're going to talk about conflicts of interest disclosure. It's a very narrow topic in terms of ethics. You know, you could, at the broadest possible sense, ethics means obviously ethical behavior. State law does not address being an ethical person. And so it's pretty narrow. It just talks specifically about conflicts of interest. Be aware that in addition to conflicts of interest laws, there's all sorts of interesting laws that apply to the government, and you'll see that chapter in here on ethics and basically crimes against the government or crimes by government officials. And so we're going to talk about very narrow in terms of the conflicts of interest. Did you get a handout that says Salt Lake County Disclosure Act on it? Okay. I really do apologize. I probably should have made sure that happened first. Anyway, we've got in Salt Lake County, we've got a document called the Salt Lake County Disclosure Statement, which you'll be getting in just a second. And it's, of course, drafted for Salt Lake County, but it's based on state statute that's applicable to any and all counties. And we are in the process of coming up with basically a non-denominational version of this document that any county can apply, can copy and make it available to itself. I'm working with the city attorneys. They want to do a similar document for the cities. There are two sets of prohibitions in the ethics and conflicts of interest disclosure law. And what's a conflict of interest first? Conflict of interest is when you've got some outside economic interest with a private employer or your own private business, then that has the potential of interfering with the independence of your judgment regarding your county job. Then you have to worry about a disclosure of a conflict of interest. And there's two kinds of prohibitions. One is a set of things that are just flat prohibited. You just can't do this. The others are a set of acts that are prohibited only if you don't disclose them. So let's start with just the plain prohibitions, which you just simply cannot have this kind of an outside employment. Again, bear in mind it only applies to outside private employment. If you work for a school district or a city or something like that, and you're also a county official, these kind of conflicts of interest are not literally applicable, though sometimes it might be smart to follow the spirit of the law anyway. First set of prohibitions deal with the nature of the job you have, and that's if you have a job where you have access to private information, confidential information that might become an economic advantage. Number one, you cannot reveal those confidences. If you work for the county as a real estate buyer and seller, so you have access to a lot of private information, confidential information about how much the county is willing to spend on this particular property. So you kind of go out, or you mention to your brother-in-law that the county's interested in buying this property. If you bought it from the current owner, you might be able to turn around with some bucks on it. That would be a big problem. So number one, you can't reveal confidences. Number two, you can't use your job to get some kind of a special privilege, and that basically means something that's not available to the public generally through the county. You can't take advantage of that yourself. Salt Lake County used to run the Salt Palace with county employees and as a county division, and one of the managers thought it would be appropriate for him to send the Salt Palace maintenance staff to his home to fix his furnace. Now this might come as a surprise to some of you, but the Salt Palace maintenance staff doesn't go around and repair people's furnaces for them. So that was kind of a big problem. That's what we mean by a quote, a special privilege. And number three, you simply can't accept outside employment that would you could reasonably expect to interfere with your county job or interfere with the independence of judgment. So those are prohibitions based on the nature of your job. Next is a set of prohibitions about gifts. And number one, you can't accept any kind of gift from anybody, including your brother-in-law, if a reasonable person would say, wow, that's going to tend to influence the way you perform your county job. That tends to not be a very big deal. The other one is you can't accept a gift from a donor who has some kind of involvement or interaction with the county, involved in any kind of county business. So a restaurant in the county that's regulated by the county health department, or something like that, somebody who's going to be bidding on a county contract. You can't accept a gift from those folks, with a couple of very limited exceptions. One of them is it's a non-monetary gift in value less than $50. It's a public award, it's a bona fide business loan, or a bona fide campaign contribution. Bear in mind that there's almost nothing you can buy for $50 anymore. We have county commissioners years ago, Salt Palace, who thought nothing of season tickets to the Jazz, okay? Well, I don't know how much a season ticket to the Jazz back in the old days cost, but it was somewhat in excess of $50. Next, did you know you can accept payment for helping somebody in a transaction with the county, unless that transaction has to do with your official county job? Just a quick example, suppose I have an invalid neighbor who can't get out, ask me, Gavin, would you go down to the county animal shelter and adopt a dog for me? If you do, I'll pay you $5 for your trouble. Okay, fair enough. So I can do that. I can accept the $5 if I disclose it, and we'll talk about disclosures here in just a second, because it's not related to my job as an attorney. Say the same neighbor a week later says, Gavin, I want you to go down to the county Board of Equalization, appeal my taxes. The taxes are much too high. If you do that, I'll give you $5. First of all, obviously, any attorney is going to laugh them out of the $5. But that's a kind of a conflict of payment for assisting somebody with a county transaction that I could not do, period, where the county transaction is related to my job. Now, what should be obvious to anybody in the room, especially anybody who recently went through an election where you have your background scrutinized, someone accepting money to help anybody with any kind of transaction with the county has got to be pretty stupid. And so rather than passing or failing the conflict of interest and ethics test, you have to worry about passing the stupid test. And so it's the notion that, you live in a glass house now. And people in glass houses besides not throwing stones, should also not accept money for helping people with a county transaction. Sorry, I'm losing my voice. Last on prohibitions is a prohibition on doing anything that is improper unless you've disclosed it. We'll talk about disclosures in a minute. This include a business that's regulated by the county, like a health department regulates a restaurant in the county. It involves anybody who's involved with a county business transaction, anybody who has an actual or potential conflict of interest. Now, the prohibition only applies if you do that without disclosing it. On those particular matters, it's okay if you disclose it. And I used to say you could get away with killing a county commissioner if you disclosed it, depending on who the county commissioner was. But that's probably overstating it. But that said, it's just county commissioners. But good question. Okay, so that raises the question, what do we need to disclose and how do we disclose it? But first, movie quotes. So, Joey, do you like gladiator movies? Airplane again. I knew Adam would have that one. What's the great truth you learned from that quote? Life's lesson. Mine was simpler. It was just mine was simpler. It was just that the world is full of perverts. Here's a great old movie. This is a great movie. I'll tell you which one it is in a minute, but this is the line. An intellectual carrot, the mind boggles. You have to go way back, okay? Science fiction. I'll tell you, the monster was played by James Arness. Huh? The Thing from Another Planet. Good shooting. What's the life's lesson? An intellectual carrot, the mind boggles. There's interesting things all over. I've got vision and the rest of the world wears bifocals. Oh, come on, you guys. Butch Cassidy and the Sundance Kid. Okay. What do you have to disclose? Okay, again, we're back to this notion that there's some things that are probably not very smart to do, but you can still do them if you disclose them. And so here's where you start again to shift over from an ethical issue to a smart or not smart issue. So just think about that as you go through this. There's a lot of situations in the law involving counties, involving anything, that you can legally do something, but it's not necessarily the smartest thing to do. Okay, what kinds of things can you do if you disclose? You have to disclose. Again, I already mentioned receiving payment for helping somebody with a county transaction. Again, provided it's not helping somebody within your personal job description. Number two, if you're owned or involved or employed by a business that is subject to county regulation, you have to disclose that. If you're employed or own or involved with a business that does business with the county, you have to disclose that. You have to disclose any actual or potential conflict of interest between your private economic interests and your county interests. And a couple of technical requirements. You make this disclosure in the form of a sworn statement. I don't know if you've got the reverse. Does it have a, fill in the blanks on the other side? Okay, this is the disclosure statement. It's sworn. That just means you have to find a notary public, and you should have plenty of notary publics around the county. It's a public record under grandma, so anybody can come in and look at your disclosure statement. So thank you, sir. And you have to disclose it 3 times. Make the disclosure 3 times. Number 1, if you're involved in some kind of a meeting where your conflict of interest or potential conflict of interest comes up in that meeting, you need to disclose it verbally, orally. Number 2, you just need to disclose it in writing whenever it comes up. So whenever you get the other job, or if you've already got the other job when you get elected or employed by the county, you disclose it when the conflict first comes up. And you do that in writing, and that's the back of the statement you've got in front of you. And then legally you're required to renew a written disclosure every year, every January, for as long as that conflict or potential conflict lasts. It applies to you as an employee. For the purpose of this, elected officials are considered employees, or to your immediate family, which is parents, children, siblings, does not include in-laws. And again, I think I mentioned this, it only applies with an outside private economic interest. Okay, think about that. Questions while I take a drink of water? All right, on the other side, you see the mandatory elements of a disclosure statement. And there's a good general rule. If you have even the vaguest question of whether or not you ought to disclose something, go ahead and disclose it. Doesn't cost anything. It's not skin off anybody's nose. We had a county auditor, Craig Sorensen, used to bring in a stack of disclosure statements about this high. And he disclosed everything in the world, that he was a junior jazz coach, and that he shopped at Walmart, and that he... The funny thing about Craig Sorensen is he also stole county gas. Okay, do you remember that? In Salt Lake County, that big, he'd use his county. And that's the point. He didn't disclose that. I don't get it. Anyway, so you have to, your name, where you're employed in the county, your county phone number, your county address, what's the outside organization, institution, business, what's the involvement between that outside business and the county, and then you just describe what the outside interest, what the potential conflict of is. And it's, it's obviously not a lengthy legal document. You just explain, I work for so-and-so, the data processing company. We have bid in the past on county contracts, and I will continue to work for them until further notice. Just something like that. Enforcement, there is a sliding scale, criminal charges from misdemeanor to felony, depending on how much money's involved in the conflict or potential conflict. And there's also a state ethics commission, which was created by the legislature just 2 years ago. And it's designed solely to enforce this particular law. I don't think they're going to be terribly busy. I've been with Salt Lake County for 35 years, and we've only had probably one of these things that was serious enough that we had to pursue it, other than saying, call the guy up and say, oh, by the way, did you file your disclosure statement? In fact, this state organization, again, the State Ethics Commission, they're designed solely to hear complaints from citizens about ethical misconduct in local government. So there's this job announcement in the Bar News about an attorney to be the administrator for this commission. And I'm not making this up. This was the AG's office who was hiring somebody. Do you remember this, Alan? It said, here's the description of the position, apply at such and such a date, parentheses. This is a part-time, all caps, very part-time job, probably no more than 4 or 5 hours per year, close parentheses. So that's how busy they were. I think it's a silly bill, but it's a Bramble bill, and so you have to kind of live with it. All right. Movie quotes. Oh, that's an easy one. There is no crying in baseball. League of Their Own. Oops, sorry. That was high, okay? I'm sorry. Whoever wants it. I'm not getting a lot of interest in Snickers bars anymore. I'm sorry. League of Their Own. What's the life's lesson? Beg pardon? That's good enough. Who said that? Nobody's fessing up to having said that. This was my life's lesson, is that some things in life are not worth crying about, and baseball is pretty high on that scale. Okay. I'm going to go really quickly through this. We'll probably catch up some time if that's okay, Adam. I just wanted to mention there's several other statutes regarding conflicts of interest disclosure. The one we've talked about is applicable just to county officers and employees. There's one for state and district officers and employees. If any of you also work with or for a district, you might be subject to that statute as well. There's one for cities. I mentioned the Ethics Review Commission on a state level. And just be aware that there's also a state statute on protecting whistleblowers in state and local government. And that's a law that says if somebody blows the whistle about some kind of misconduct in government, and that could be either criminal kinds of misconduct, or it could be unsafe working conditions, it could be discrimination or any of that kind, they blow the whistle, it's kind of, and they do it in good faith, then it's kind of like King's X, and you can't discipline an employee for blowing the whistle. It's an interesting fact about whistleblowing is that when an employee knows that the other shoe's about to drop, they often find a whistle to blow. And so that becomes kind of a way to protect themselves. But the test is whether the blowing of the whistle, in other words, alerting the appropriate authorities to misconduct in county government, was done in good faith and on good cause. And there's a pretty substantial private cause of action. That employee, that person who is blows the whistle, can bring a civil lawsuit against the county for, I think it was triple damages for termination, and then the county itself, or the county officer employee, is also subject to a personal fine and to discipline. So that's basically it for conflicts of interest disclosures. Questions on that? We're going to go on real quickly to the role of county attorney. And I'm going to expand this just a little bit without actually expanding the time to just basic ideas about the roles of the independent elected officials. Okay, so that applies to most of you folks. And we're talking about the interrelationships between those independent elected officials and each other and their relations with the county commission. What can the county commission tell the sheriff or the assessor or the treasurer to do, and what can they not tell them to do? So there's a couple of chapters in the big handbook, one on county officers and employees and one on civil liability. Johnny already covered most of the one on civil liability, but I'll just mention a couple of things about the county attorney in there. And I had a county elected official, who was it now? I think it was our surveyor, said that when he took the job, he said, whatever you do, don't tick off the sheriff or the county attorney, because they're the two officers that can put you in jail. All right. There's just a couple of basic ideas about what it means to be a county elected official. Most, in fact, it ought to be 100%. I'm going to refer to the independent electeds. That means the elected officials, everybody other than a county commissioner or county council member, okay? So these are the guys that are in charge of the sheriff's office, treasurer, auditor, clerk, surveyor, county attorney, those folks. Just shorthand, I'm going to refer to those as the independent electeds. An independent elected's job duties are almost always established completely by state statute. And you'll find a number of sources of the law, usually in Title 17 of the Utah Code, and you'll find this in the handbook, exactly what those statutory duties are. And here's the trick. You don't have to do any other duties than those statutory duties, okay? So, suppose in your county, the personnel function, HR function, is run by the county auditor, or the purchasing function is run by the county auditor. I want to ask for a show of hands. That's okay as long as there's an agreement between the county commission and that elected official that they'll do this extra statutory duty. Technically, the HR director or the purchasing agent ought to work directly for the county commission. That's minor, but semi-interesting. Next is just a quick notion to distinguish different kinds of these independent elected officials. There's a distinguishing characteristic between whether their job is discretionary or ministerial. And a discretionary job is a job where the individual elected official has tons of discretion about what or how they do their job. And probably the two primary examples are the attorney and the sheriff. The sheriff has a statutory duty to make all lawful arrests, but everybody recognizes that law enforcement officers at any level have the discretion as to who to arrest based on circumstances, the nature of the crime, all sorts of those kinds of things. By the same token, the attorney has tons of discretion about who he's going to prosecute and about the nature of civil duties that they perform. A ministerial independent elected officer is typically a person that really doesn't have any discretion about what they do. And their job basically involves keeping records like the recorder or the clerk. We really don't have a discretion. Somebody brings in a record to file, a property record to file with the recorder's office. As long as that property record meets the statutory requirements, county recorder doesn't have any legal authority to say, yes, I'm going to accept it, no, I'm not. So the two offices that are most often considered ministerial would be the recorder and the clerk, and then everybody else fits kind of somewhere in between. A recorder or a treasurer, for instance, may have a lot of discretion as to where to and how to invest the county's money within the limits of state law and maybe within the limits of county ordinance, if there is an ordinance on that. With an independent elected and with their deputies, all independent electeds have deputies. It's not just deputy sheriffs, so deputy county attorney, deputy treasurer, deputy clerk. Deputy means you stand in an alter ego position with the elected official. That means if there's a statute that says the sheriff shall make all lawful arrests, a deputy stands in the same position as the sheriff for purposes of that statute. In fact, the term deputy, depute, comes from a Latin term that means to stand in place of. There are such things as special deputies, which is somebody that doesn't necessarily be covered by your merit system. If you have a merit system, it's someone who's brought in for a special project for a limited time. In my shop, it might be an attorney who would specialize in, say, copyright infringement, because we don't have attorneys that specialize in copyright infringement. So a special deputy would be somebody who has a limited scope of their job or a limited time frame. And the other interesting technicality about deputies is if they are performing the principal's statutory functions, they had better be a deputy, which means sworn in, have an oath of office. And there's a great old case out of Salt Lake County about a deputy auditor who conducted a whole bunch of May tax sales, and it turns out this person had never been deputized. And all those tax sales are all invalidated because they're outside this employee's duties. The salary and supervision are two different things in the initial hiring. When a elected official wants to hire a deputy, he has to get the permission of the county commission, and the county commission has the legal authority to set that salary. But once that's done, the county commission has no more control over that independent elected official's deputies. That control resides completely with the independent elected, and the county commission basically has no authority regarding disciplinary action or any of that kind of stuff. There's a great old case out of Grand County. Who's Grand County? Does anybody remember a farmer by the name of Murphy? This goes back to 1950. Of course not. Murphy thought it would be a great thing to run for county attorney, and he didn't have a bar license, and that's okay. A lot of attorneys shouldn't have bar licenses. And he got elected. And the county commission says, just wait a minute, you can't go to court, you can't prosecute, you can't do nothing as a county attorney. And so they changed his annual budget from, I think it was like $10,000, not a tremendous fund at that point, to $10 a year. So his entire office budget was $10 a year. And he goes to court, and the court says, county commission, you cannot use your budget setting authority to destroy an office, to make it impossible for the office to function. They said, however, county commission, this was the further holding, you can decide whether or not there is a problem or there is a value to be addressed. You just have to use discretion, be rational, support your decision. Obviously, in this case, they would have supported their decision by saying Murphy can't go to court. He's not a member of the bar. Let's see. Questions at that point? Anybody have a question? When I say don't hesitate to ask questions, I don't mean just with the other elected officials or around the table in the conference room, but don't hesitate to ask your employees, your deputies, especially those who've been around for a long time, how to do your job. Most would be flattered, I think, to be asked. Which brings us to communication. Surely you can't be serious. I am serious, and don't call me Shirley. Airplane. Adam kept quiet about that one. All the way back. I don't think I'm going to be able. All the way back. Oh, get back. Perhaps later you could kiss me on the veranda. Lips would be able to. Three amigos. You have a plethora. Would you say I have a plethora of piñatas? There's some movies that are just great for movie lines. Sort of the eternal truths we learned from those two quotes. This is very important for your job in the counties, okay? Say what you mean, that works. I was thinking define your terms. You know, if you're talking about Shirley, make sure you define Shirley. Okay, let's talk specifically now about the attorney, and we'll take just a few minutes. I think most of you, have a lot of sense of what an attorney does. There's a couple of things that you need to know that you might not be completely aware of. Attorney does two main things. He serves as the prosecutor for the county, and this is interesting. When he serves as prosecutor, he really doesn't have the county for his client. He has the state for his client. Have you ever been in a criminal prosecution and the county attorney addresses himself in court as the state? The state rests its case. So that tells you an interesting, important thing about being an independent elected official. And the fact that your duties are defined by statute. Most of you are actually acting as state officials, performing state functions on a local basis. Okay, that's kind of a helpful concept to get in mind because it can kind of define some of the things that you do and don't do. Prosecutor, for instance, for your information, which is unique, is the only county constitutional office. The only office mentioned in the Utah Constitution is county prosecutor. Go ahead. That's constitutional. That means the legislature can't change whether you have an elected prosecutor. You certainly can't do it by county ordinance. What kinds of things can you do with the independent electeds by county ordinance? Clerk auditors, what can you do? You combine the offices, right? And that's very common. I think about a third or a half of Utah counties have combined office of clerk auditor. Another commonplace one is surveyor recorder. Other combined offices? Beg pardon? Clerk treasurer? Okay. Some of those make a lot of sense just in terms of the similarity of job duties and the burden otherwise on the particular officer. County attorney there's only one DA in the state, that's in Salt Lake County. There's a statute that allows counties to create what's called a prosecution district attorney, which can be either just the boundaries of the county or can join in with other counties, and in so doing can create a district attorney office. In our county, the district attorney and the county attorney are combined offices. The county attorney prosecutes state felonies and county ordinances, and state infractions or city ordinances are prosecuted by city attorneys. And then obviously the county attorney has significant civil legal duties. And in those civil duties, who is the county's client? There is, or used to be, more so in old days, a big question about who's the attorney's client, who's the public sector attorney's client, who's the county attorney's client. And the reason that becomes an issue is because the attorney, by both statute and the ethical rules that they're bound by, owes certain duties to the client and doesn't owe those duties to somebody who's a non-client. And so that becomes fairly significant. And most significantly is that the client basically has the authority to tell the attorney what to do, but only in the capacity of being, and I'm talking about civil attorney. The prosecutor's client is the state. So the county commission has almost no legal authority to tell county when he's wearing his prosecutor hat what he has to do or can't do. And the question comes down basically to this: who controls the county's legal issues, and what duties does a county attorney owe, and to whom does he or she owe them? There are some of the duties, for instance, in the ethical rules say there's a duty to competently represent the client, to abide by the client's decisions, to be diligent in following up on client direction, to keep the client informed, to maintain client confidences, and to avoid conflicts of interest between multiple clients. So who's the county attorney's client? It's basically the county. And that comes from two sources. There's a ethical rule that says an attorney who works for an organization has that organization as the client. And the other source is a very famous, at least in local government law in Utah, a Supreme Court case called Salt Lake County Commission versus Short. And some of you who've been around a little while might remember Doug Short. Doug Short had an ongoing feud with the county commission. This actually eventually led to the adoption of the county commission, or the county council form of government. And basically they didn't play well together. And so there was a lot of issues that came up. So the Supreme Court, and one of the things was that, number one, Short wouldn't do what the county commission asked him to do. And number two, the commission says, well, if you won't do it, then we're going to hire an outside attorney to do it for us. And so that goes to court. The court makes 3 rules about the civil attorney's responsibilities. Number one, as I mentioned, that the attorney, and I'm talking primarily about civil duties, that's the one you're going to interact with most. You should, with any luck, have nothing to do with the attorney in the prosecution function. The attorney in the civil function represents the county. He or she does not represent any county officials, any county employees, any county boards or commissions or other bodies, except to the extent that they're acting within their county functions. Okay? So that's where we can still get some educational credit for trying to figure out what that means. I was afraid you'd ask that, Wade. It says that the county attorney does not represent the county commission, does not represent individual commissioners, does not represent the auditor, treasurer, does not represent the individual employees, except, as Johnny explained when we were talking about liability, when we go to court over say an automobile accident, county street maintenance guy runs over a vehicle, private vehicle, then the Governmental Immunity Act requires the county to represent that driver in the civil lawsuit, but his client or her client is still the county, not the county commission. So when you guys, especially you county commissioners, get in a fight with your county attorney, that might be something he pulls out of his back pocket. He says, "You're not my client. I don't have to abide by those ethical rules about attorney-client relationships because you're not my client." Except for the second part of the decision in the Commission versus Short case. This says that the client's communications from the county flow through who? County commissioners, county commissions, county auditor, assessor, any county official who is speaking or dealing with his or her statutory functions has the authority to say, regarding this issue, county attorney, this is what the county says, and you have to abide by your ethical responsibilities to the county because I have the authority to speak on behalf of the county for this particular issue. Pretty complex. Hopefully it doesn't come up very often. Oh, one other third decision out of the Short case. The county commission cannot hire their own attorney. They can't fire the county attorney as an independent elected official. Now, if you're in a separation of powers form of county government, then both the county executive and the county council can hire their own attorney. But that's a specific statutory exception, and that attorney for the county council or the county executive has no authority to speak on behalf of the county. You got differences and disputes about that kind of stuff. You go first to the Attorney General's office. My experience is that the Attorney General's office will say, "We don't know, you figure it out." Number two, the Utah Bar. And my experience with the Utah Bar is, "We don't know what it means, you figure it out." And ultimately, you go to the courts, and that's obviously what we had to do with the Commission versus Short. Yeah, go ahead. Yeah. You know, and that's fine. Again, that's part of his or her job in terms of representing the county. It's not uncommon for an individual official to get sued in their own name. The sheriff gets sued all the time. And again, that's a function of the Governmental Immunity Act that says, even though I represent the county, I can appear in court on behalf of these client constituents. It all comes basically from law of corporations and attorneys' relationship with corporations. Can you picture a problem in the corporation where the corporation board of directors says, "We want to do this," and the shareholders say, "We want to do that"? That becomes a conflict of interest for the attorney. And there's all sorts of rules and laws that govern that in private corporations and say at what point does the attorney for a private corporation have to shift his or her allegiance. But the same kind of issue comes up here. Another thing to bear in mind is that this function of speaking on behalf of the county is an executive branch function. And so that means in counties with separation of powers forms of government, it's not the county legislative body, it's the county executive or manager. And in county commission forms of government, it is the county commission because the county commission is the executive for most of the counties. And there's an exception that when the action is brought in a specific insular kind of function that's overseen by an independent elected, the most common being a tax assessment problem, then the assessor or the Board of Equalization controls the lawsuit, not the county commission, even though they tend to be the same things. That's pretty confusing, and it's probably more than you needed to know. I think the thing to go away with this, I forgot one other really important aspect of relationship between county commissioners and independent electeds. there's a statute that says the county commission, well, first of all, I'll start with county commission's basic function. It's a legislative branch body. It adopts ordinances, which are laws that are binding on the county and its citizens, and it sets the budget. So in those two things, a county commission has the authority to control what happens, obviously, within individual offices. But according to the Murphy case, they can't cut the budget so much that you can't perform your function anymore. So that's number one. Number two, the county commission in their legislative body, or legislative authority, which is ordinances and rules and regulations, can adopt ordinances and regulations that govern general activities across the county. They can adopt a purchasing policy. They can adopt a travel and training policy. And those policies and requirements are going to filter down to the individuals, even deputies and other officials within the elected officials' office. But what the county commission cannot do is they cannot interfere with the elected officials' technical duties as they're set out in state statute. So the county commission can't go into the assessor's office and bang on his door and says, you need to change this practice in terms of assessment. They can't go bang on the sheriff's door and say, you need to send more deputies out to patrol in the canyon than you're doing now. They can ask, and those kinds of things tend to get worked out through interaction and cooperation. But just bear in mind that one of the advantages of being an independent elected is that you work for the electorate. You don't work for the county commission. Okay, a couple of last quotes, perfect quotes to end today. Gentlemen, you can't fight in here. This is the war room. Dr. Strangelove. I've only got enough for me, so sorry. Insanity runs in my family. You could say it even gallops. Arsenic and Old Lace, great movie. Anyway, I'll finish with where I started. I'm more than happy to assist in any way I can. I enjoy working with UAC and with individual counties and elected officials across the state. I will insist that you listen to your own county attorney first, or I will help your county attorney to the extent that I can. And good luck, and I hope you don't regret this any sooner than the 1st of January.